I want to start with actually what this regulation does, because I've heard about 4 different descriptions now. To whom does it apply and to whom does it not apply?
Sure. So it applies to those coming across our southern border who have not applied for asylum in a country they have passed through on the way to the United States. So not Mexico, for instance, because they're next door. But for those beyond Mexico, they would be required to apply and then be denied and be able to prove they were denied asylum in a prior country. Because asylum is about safety, it's not about forum shopping or preference. And this requirement is in part response to the quadrupling of asylum cases we're seeing that is tied in with in the last 10 years, which is tied in with the crisis we're facing at the border.
And if, in fact, someone from a third country, we're really talking about Central American countries, I think, as a practical matter, were to apply in Mexico and be denied, could they then apply the U.S. for asylum?
Yes, they could. And just to correct one point, while raw numbers, you're right, what's coming over this southern border is mostly from South and Central America. We are now seeing the southern border used by people from all over the world as an avenue in where they might have tried something else prior to the crisis we've got at the border. But yes, to your question, if they apply and are denied in a country on their path to the United States, they may apply in the U.S. And we have a long tradition of generous asylum, which has been, frankly, swamped by a lot of fraudulent claims. And what that does is it clogs up a system for the legitimate claimants. And this regulation will go a long way to helping us clear our over 300,000 case asylum backlog. And also the immigration judges over in the Department of Justice are closing in on a 900,000 case backlog. And as I said, being swamped at the border plays a big role in this.
So I know you're an accomplished lawyer in your own right. As I recall, you were Attorney General of the Commonwealth of Virginia. I'm an old lawyer as well, so just indulge me and condescend to the language for a second. The statute, 18 U.S.C. Section 1158, says in part, any alien who is physically present in the United States or who arrives in the United States, irrespective of such alien status, may apply for asylum. Could you just give me a sense of why this regulation doesn't go afoul of that statutory language?
Sure. Well, there are several other aspects of the Immigration and Naturalization Act that are at play here, and those from both parties, administrations from both parties, have utilized the regulatory authority similar to how we're using it. Different examples, but same legal authority in the past. And as you noted in the introduction, we're likely to be sued over this. There's very little we do these days that doesn't involve litigation, unfortunately. But I've looked through the legal foundation of this regulation, and it is very clear, it is very strong, and it relies on a long history of similar actions by the Attorney General and later the Secretary of Homeland Security. And I say later because, of course, Homeland Security is only 16 years old as a separate department. This is a jointly issued regulation. It is strongly founded in the Immigration and Naturalization Act. And while we expect litigation, we do expect to prevail and to implement this rule starting tomorrow.